Hey, how's it going out there, Funk fans? It's Professor Phil. I'm back at it again. And I want to break down what I had posted on Facebook that I promised to make, which was basically the principle of selling one's debt in the most generic way, how debt is created in the first place. Okay? And I think that for the most part, most debt contracts aren't necessarily based upon what you receive. It's based on what you signed up for. So let's just go through an employment contract, for instance. Let's read it together. An employment contract, or contract of employment, is a kind of contract used in labor law to attribute rights and responsibilities between parties to a bargain. Bargain means a trade or exchange. So in essence, what that means is that when you sign for a contract, you've quite easily assumed the position of giving somebody the assumption that you've agreed that the contract you are going to be the attributing principle to, just simply on the basis of selling your labor, is that the bargain of your price of your employment is based on who is purchasing effectively your equitable energy, which you put into something that will come out of the contract, and which will then supply that attributing right and financial responsibility between the parties based on what you bargained for. Okay, it's all about negotiation. All right. The contract is between an employee and an employer. Now, here's the funny part. Here's the thing that a lot of people don't know. Most corporations, when they are paying taxes on your behalf, when they withhold, they are in fact a withholding agent. If an employee says he's not a withholding agent, he then has to put that in writing, which of course I'd prefer you to get. And when you get that, you send it to the IRS, showing that every dollar you receive is a deduction. That's 100% written off. That means that every dollar you have otherwise received is no longer taxable. One of my little tricks of the trade, but hey, what the hell? Might as well give you something, right? All right, let's continue. It has arisen out of an old master-servant law. It has arisen out of an old master-servant law. Interesting. Used before the 20th century. That means, just like an indentured slave, you have otherwise agreed to the terms and conditions of allowing someone to use you as a servant under the law in regards to the old master system, which was created by who? Massa. Yes, very much. So, right along, but generally the contract of employment denotes a relationship of economical dependence and social subordination. So in other words, you will yield to the price of an economical surplus based on the employment's contract to facilitate not an absolute trade, but a trade in which the bargain sufficiently suffices where the law is required, and it is otherwise giving you the idea, the assumption that what you're actually being paid for is equitable under the terms and conditions of being sold an equity contract. An equity contract is how much you make economically, which will socially impact your subordination, which is to otherwise feed you an allowance to make you feel special, which in reality you're really not. Okay. In the words of controversial labor lawyer, now read what he says. The relationship between employer and an isolated employee or worker is typically a relation between a bearer of power and one who is not a bearer of power. That's interesting. So all you people pumping your fists while you're financing the economical surplus of the government, who then turns around and puts those monies into bullets, and which then goes into your children. Well, you're doing a great job by working for those in which you bear no power against. In its inception, it is an act of submission. Interesting. So if you're pumping your fist, are you in submission? Or are you egregiously saying everything is wrong, but that the depiction of your employment is the only way for you to go out and show your support for your ideology, which does not separate you from your subordination, which you're still under? We'll get back to the principle for a moment. In its operation, it is a condition of subordination. Wow, a condition. So basically, well, let's just forget about the relationship because you're still in a relationship with your enemy. However, such the submission and the subordination may be concealed by the indispensable fidget of legal legal mind known as the contract of employment. It's interesting how they just hide everything in plain sight. The main object of labor law has been and will always be countervailing force of counteracting the inequity of bargaining power, which is inherent and must be inherent in the employment relationship. Sorry for that, I got cut off. But it goes on to say, the main object of labor law has been and will always be a countervailing force of counteracting the inequality of bargaining power. And I made the mistake of saying inequity repeatedly, as a matter of fact. Please strike me for that. Which is inherent and must be inherent in the employment relationship. Let's go over to inequality for a moment and look at exactly what this means. Why'd you pump your fist? Inequality of power, bargaining power in law, economics, and social sciences refers to a situation where one party to a bargain, contract, or agreement has more and better alternatives than the other party. The result in one party having greater power than the other to choose not to take the deal, a choice in which you actually have power over, you don't, and makes it more likely that the power will gain more favorable terms and grant them more negotiable power as they are in a better position to reject the deal. So in essence, inequality means that with no systemic balance sheet between those in which have power and those that have no power, inequality is an absolute. It's a paramount feature of economical, social, and power structures put in place in which bargaining power is taken completely off the table because you don't know how to negotiate. Inequality of bargaining power is generally through to undermine the freedom of contract, which is basically to otherwise stick it to you in such a way that you can't negotiate any other term and condition that would apply based on what they believe your equitable price really is. Federal government says you're worth $7.25. That's the bare minimum if the employer sees fit. Okay, and it goes on, resulting in a disproportionate level of freedom between parties, and that represents a place in which markets fail. Now let's go look at markets that fail. Okay, and it says here in neoclassic economics, market failure is a situation in which the allocation of goods and services by free market is not efficient, often leading to a net loss of economical value, which is what happens in most societies that decide to do what? Give up their bargaining power because they believe that in some way, shape, form, or fashion, someone is going to come in and give them equitable relief. Now, how are you going to get equitable relief if you're at the bargaining table? And for the most part, the contract under the terms and conditions of what you've been employed for, and they can change those terms and conditions whenever they see fit, that you don't have a negotiation at the table because you're not the one contracting on your behalf. They're contracting for you, and they're saying how much you should get paid. And they say that as a withholding agent, they say how much you're going to pay the government, how much the government is going to receive, so on and so forth. And it goes on. A contract of employment is usually defined, this is the terminology, means the same as a contract of service. A contract of service has historically been distinguished from a contract for the supply of service, the expression altered to imply the dividing line between a person who is employed and someone who is self-employed. The purpose of dividing lines is to be attributing rights to some kinds of people who work for others. Those could be the right to the minimum wage, holiday pay, sick leave, and fair dismissal. A written statement of a contract, the right of the I believe that would be organized in a union, and so on. Okay. The assumption is that genuinely self-employed people should be able to look after their own affairs and therefore work therefore work they do for others should not carry with it an obligation to look after these rights. Right. So we got contract. We got employment contract in and of itself at the hem of this thing. Now here's where we get into the real goodies here. Okay, we're gonna go over the tender of payment. Let's read it, and then we're gonna examine what exactly you can tender, what can be contracted for tender, how you can exchange tender in exchange for favorable contractual rates, and the return of not only the monies that you ultimately were in recourse of, but to be able to pledge further debt while canceling new charges that otherwise would have been used to benefit other entities, infrastructure, societies, corporations, and government. All right, and here goes the first paragraph. A, if tender of payment of an obligation to pay an instrument, and that's for instance your employment contract, is made to a person entitled to enforce the instrument, the effect of tender is governed by the principle of law applicable to tender the payment under a simple contract. This is how you are not only employed, but this is where the statutory term and condition finances their debt and pays you to essentially charge off what they created. They created finance to otherwise hand to you as if they're borrowing money, or essentially lending you money and allowing you to look like the borrower, them tendering the debt, charging the account off, and then asking you to repay the government back for what they borrowed. Isn't that great? Economical surplus. Just wonderful. Okay, and we go on to B. If tender of payment of an obligation to pay an instrument is made to a person entitled to enforce the instrument and tender is refused, there is discharge to the extent of the amount of the tender, which of course your employment contract, if it's dissolved and they refused to otherwise pay, the discharge to the extent and amount of the tender of the obligation of an endorser or an accommodation party having a right of recourse with respect to the obligation in which the tender relates. That means you can go after the employer for violating that contract, or otherwise not fulfilling and refusing to tender that obligation, which is to otherwise pay what the contract stipulates. Even if it doesn't stipulate in the contract, it's going to have some type of rate that stipulates how much you're being paid or how much you're supposed to receive. We're going to see. If tender of payment of an amount due on an instrument is made to a person entitled to enforce the instrument, the obligation of the obligor to pay interest after the due date on the amount rendered is discharged. If the presentment is required with respect to an instrument and the obligor is able and ready to pay on the due date at every place or payment stated, at every place of payment stated in the instrument, the obligor is deemed to have made tender of payment on the due date to the person entitled to enforce the contract. Again, if you add interest, for instance, to an obligation such as a employment contract, then the tender would be discharged on the principle that they're required to pay. Now, this is after the presentment is given to you. So if you get the presentment, like a check or something like that, and you go present it saying that there's interest on this and they're obligated to pay, the first portion of the obligation of this particular section here, C, states, and I'll go from the obligation of the obligor to pay interest after the due date on the amount tendered is discharged. That means that ultimately they're not responsible for the liability after the discharge, once it's been presented and been paid. And it goes on, if the presentment is required with respect to the instrument and the obligor is able and ready to pay on the due date at every place of payment stated in the instrument, the obligor is deemed to have been tendered of payment on the due date of the person to enforce. So basically, they're upon presentment of that particular instrument at the time, even though it says in the first section that it would be discharged, the tender amount in respects to the instrument at the time of it being presented and able and ready to be paid over on that due date, you will be paid with interest. And then we're going to go over to bond tender. Now, this is interesting because I went and looked it up and I said, this would be nice to talk about. And the main reason why is because everybody in some way, shape, form, or fashion pays utilities. Perfect example, as a matter of fact, is that in the state of Indiana, one of the biggest ones is, I forget exactly the name. But if you look up their bond proceeds, I'm actually going to look it up here and I'm going to record that and show you exactly what I'm talking about. They oftentimes bid on electric, water, and basically all your supplies and demands based on the utilities that they sell to the state, county, and municipalities, who otherwise allow them to groom the bond market to finance finance under the extension and the auspice of bondholders who want to facilitate, ultimately trade in that particular in the utility sector. Ultimately, anything that's going to make a bondholder or an investor money at the end of the day, they want to, in some way, shape, form, or fashion, aggregate the supply of that demand. They want a piece of it, in other words. All right, so we're going to go on and read it. A bond tender offer, BTO, also called a debt tender offer, a DTO, is a corporate financial term denoting the process of a firm retiring its debt by making an offer to its bondholders to repurchase a specific bond, specific number of bonds at a specific price and is that specified? Am I tripping? I think this, specified time, at a specified price and a specified time. Right. Firms use, and I have to put my glasses on here. I'm sorry, guys. Firms use these offers to refinance or restructure their current capital structure. On the open market, many debt securities trade below their face value, thus making repurchase of debt attractive to a firm. In the case of a BTO, the firm offers to buy bonds above their market value, although still below face value. However, these are generally non-negotiable with the offeree, since only a minimum amount of bond repurchasers are allowed. Now, here's the funny part. If you have a corporation and you're behind your utilities, you can actually offer, that's right, you can do a bond tender offer to buy back how much in utilities you intend on paying, and then start sharing. Oh, look at this, hold on. You can actually share with anybody that's under the company. So let's say 5 people up the block, if you're talking a shared volume of how much in gas, lights, water, and things of that nature. They actually do these in a lot of housing development contracts. And what happens is they actually reduce the ratio of how much they'll have each individual pay, which in this case, let's just say it's a bunch of houses. You're on a block, got a bunch of houses down the block, and you tell everyone, look, we fall under this company, and we all use the same utilities. What we're going to do is we're going to do a bond tender offer. We're going to reduce the price. What we're going to do is we're going to pay over time for what would be considered an overpriced utility. Now, in the case of a utility company itself, looking at that, they're saying, we can refinance the difference. They'll pay the principal and probably the interest, but knowing you're not going to pay, your utilities are forever. So in essence, you're going to continue to pay it anyway. But if you go and you do a bond tender offer, and everybody on the block, everybody is not necessarily equitable, but you can say that with a bond tender offer, now you're able to turn around and say, you know what, we're reducing the utilities by 45%, and yet all of us is getting the same thing. And we're able to charge off ultimately what we would have otherwise paid in any other bond tender offer. That means supply would be a guarantee, because the plentifulness of those that aren't able to make the financial grade, but guaranteed that they're going to pay a portion over that given amount of time, saves a bunch of money. It saves everybody money. You know why? Because your company is ultimately buying your debt and selling it back to the company at the rate you give it, even though it's overpriced. Now, a lot of times they like it overpriced because the underlying face value on the fair market is a whole big different story. All right. Matter of fact, we're not going to go into bond rations, because if we go do that, then it gets a little complicated, and reading it, it can be overwhelming. But To give you I guess the general principle of how all this works is that debt is actually credit. They're both one and the same. Okay, one has to cancel the other. And the reason why that is so is because if you have a check and go and cash it, then you go and give cash in exchange for a check. Both are canceling one another out because you're creating one to finance the other and the other to offset the balance of what has been created. So essentially, they're both one and the same. You never see a negative or positive sign behind any particular debt unless that is a markup or markdown price on the facility of trade. That means that agreement between you and that third party. In any case, it's Professor Phil. I've had a wonderful afternoon, and you should too. Peace.